Inibehe, how much of this Nnamdi Kanu development can you share with us? What do you know?
Thank you once again for inviting me. I have followed the Nnamdi Kanu's case right from when he was arrested, detained by the State Security Service, to when the federal government eventually filed charges against him at the Federal High Court in Abuja before the Honorable Justice Binta Nyako, to the point where he was admitted to bail on various stringent conditions, and subsequently the military invaded his home, and then a couple of people were killed. The palace of his father was desecrated, and he narrowly escaped and fled the country. You know, one conversation that we must have is this: when matters of this nature arise, it is always important for us to get to the root of it. The reason why we are having this discussion today, the reason why the Court of Appeal judgment came, is because the Nigerian army invaded the home of Nnamdi Kanu. Had that very tragic incident not took place, Nnamdi Kanu probably would not have left Nigeria. Because when we say he jumped bail, I have some difficulty agreeing with that, when someone basically escaped for his life. But that is an argument for another day. Now, granted that he left Nigeria and found his way to the United Kingdom, where he's also a citizen, and then the federal government went back to court. Nnamdi Kanu was nowhere to be found. There was even an attempt to go after his trustees, and at some point the court even threatened to have his sureties forfeit the bond that they have entered while signing as sureties for him to be released. Now, eventually the court had to issue a warrant for his arrest, and then the federal government did not approach the government of United Kingdom with an extradition request, because I can confirm to you that there is what is called a mutual legal assistance treaty between Nigeria and the government of United Kingdom. And indeed, under our Extradition Act, Nigeria had a legal obligation under his own law, and of course under international law, to ensure that where a fugitive, where someone is wanted in respect of an offense that is committed in Nigeria, Nigeria must formally request the country where that person resides to bring that person, that is to put it in a layman's language, to produce that person or allow the Nigerian authorities to take custody of that person. That process is what is called the extradition process. And we have seen that with the case of Nnamdi in Niger Republic, if I'm not mistaken. Now, we have also seen that in the case of Abayari, where the United States government made a request to the Nigerian government, and then the same Malami, who is now issuing statements, went to the Federal High Court and basically, sabotaged the entire process by allowing the NDLEA, the Nigerian Drug Law Enforcement Agency, the National Drug Law Enforcement Agency, to file charges against Abayari, even when the extradition proceedings was ongoing, contrary to the provisions of the Extradition Act. The point I am making is that under international law, and indeed under our law, there is a clear procedure by which a fugitive is to be produced to stand trial. Now, what has been the response of the Nigerian government when this issue of extraordinary rendition was raised? Silence at the Federal High Court, and that is the point the Court of Appeal has made yesterday. The Nigerian government had absolutely no answer to one important question: how did you secure the attendance of Nnamdi Kanu in court? Because except we are a banana republic, except we are a country that is not governed by laws, you cannot go to a foreign land and then abduct somebody and forcefully bring that person into Nigeria and say you want to put that person to trial. So if we allow that kind of precedent to stand, if the Court of Appeal were to say there is nothing wrong with extraordinary rendition, that will be a fatal attack on the Constitution of Nigeria. It will be an attack on international law. And let me also highlight this. Under Section 2 of our Constitution, the Constitution says that the Constitution shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria.
Yeah.
In other words, if you look at by the combined effect of Section 1 and Section 2 of the Constitution, the Nigerian Constitution does not have extraterritorial application. In other words, you cannot go to the United Kingdom, you cannot go to Kenya to enforce the provisions of the Nigerian Constitution.
Yeah.
Let alone an act of parliament.
Yeah, Inibehe, just a minute. Two key words here: discharged and acquitted. When are you discharged and when are you acquitted?
Well, these are, terminologies that have implications in law. But let me also caution that there are circumstances under the law under which a discharge can be taken as an acquittal. And I think Nnamdi Kanu's case is within that contemplation. We will wait to see whether there will be a different outcome, really, because I have read the statement of Malami that, he was only discharged. He was not acquitted. So having been discharged, right, why are you still keeping on to him? Can you hold on to someone who has been discharged in law? Acquittal is typically when a case is determined on the merits and the court finds that the prosecution has not proved its case. And that is some form of absolute exoneration. Whereas a discharge can arise from several circumstances. For example, where the charge against a defendant is defective. That person can be discharged, which ordinarily would entitle the prosecution to refile the charge under some certain circumstances. Now, in the case of Nnamdi Kanu, right, the issue is very simple, and it is this. When you look at the charge that was brought against him, even the Honorable Justice Nnamdi of the Federal High Court agreed that at least eight of the counts in the charge were incompetent and struck them out. There was a further appeal to the Court of Appeal. From what I have read, because the CTC of the judgment of the Court of Appeal is not out yet, but from what I have read, including the comment made by Chief Mike Ezekume, it appears the Court of Appeal has even struck out the remaining counts. And if that is the implication, it means that today, Nnamdi Kanu is not standing trial before any court. So let nobody say that there is a subsisting case for which Nnamdi Kanu is to answer to. Okay. And that brings me to the provisions of Section 287 of the Constitution.
That matter.
Section 2, which says...
that matter for which, he was standing trial before he left Nigeria, citing threat to his life.
Yeah.
Is that particular matter statute barred at this time? Can they go back, because the Attorney General was referring to that there were some things that happened before he fled Nigeria? Can they go back and file fresh charges based on what
had happened?
What had happened for what they were trying him for at that time?
It is very doubtful, really, because the question is, before how many courts in Nigeria is Nnamdi Kanu standing trial? Is Nnamdi Kanu standing trial for more than one charge? To the best of my knowledge, from the findings I have made, it appears he only stood trial before Justice Nnamdi for one charge that had several counts. That charge no longer exists in law. So this argument that he was only discharged and that the issue that took place before the extraordinary rendition is not affected, for me, is baseless in law. What the Court of Appeal has done is to say that the very basis upon which you brought him back to continue to face trial is defective. But let us even assume for a second, right, that Malami is right, that they have the power to refile charges. You cannot hold a citizen in anticipation of a charge that you intend to file. Because for them to say that they will explore legal options, what legal options are you going to explore? I find it quite condescending. It is an insult on the judiciary for the Court of Appeal to give a decision. And then the National Security Council had to meet, as I read today, and then the AGF had to even issue a statement to say, we are considering what we are going to do. In other words, we want to review whether to comply with the order of the court or not. For me, that even takes me to the point I've always made, that in these political cases, the intention is not really to punish for a crime. It is just an attempt by the government to show power. Because if you are saying that Nnamdi Kanu has committed an offense, you cannot try him outside the law. You cannot try him outside the due process of law. And this comment is coming from no other person, the Attorney General of the Federation. Now, when you look at Section 150 of the Constitution, it says that the AGF shall be the chief law officer of the government of the Federation. So when you have the chief law officer desecrating the sanctity of our judiciary, basically giving excuses why they will not comply with the subsisting and valid order of the court. That begs the question, are we really running a democracy? Because we have read the story of Diko, who was also abducted abroad and brought to Nigeria under a military dictatorship, under the same General Buhari, if I'm not mistaken. And now history is repeating itself. The Court of Appeal is basically punishing the Buhari regime by saying that because you did it to Diko under a military dictatorship and you got away with it, you cannot repeat it under a democracy. That's what the judgment of the Court of Appeal means.
They actually tried to bring Diko here, but failed.
Yeah.
So they didn't succeed. That abduction didn't succeed.
Yes, they didn't
Yes, I'm
because
saying
the secretary was able
that
to
you tried it. I'm saying that you tried it under the military, right? And you got away with it, even though it was not successful.
Yeah, it was
now,
not successful.
you even succeeded under a so-called democracy. Are we saying that there should be no consequence? That the Nigerian state can go to a foreign land and just abduct it? Look at Niger Republic that we want to look down on. Look at what they did with Nnamdi. They insisted that the process of law, the due process of law must go through. Why are we reluctant to insist on the rule of law? And for me, and this is the point I want to make.
Inibehe, I'm sure you meant Benin Republic.
Benin, yes.
Okay, Benin.
Yes, Benin Republic.
Quickly, in 30 seconds. What next, in your estimation?
Kanu has to be released immediately and unconditionally. The alternative to that would be for the Nigerian Bar Association to immediately commence disciplinary action against the Attorney General of the Federation. Because we cannot tolerate this. When the court has given an order, look at the ASU strike.
Inibehe, we thank you very kindly.
That the court has given an order for ASU to resume. So you cannot be picking and be choosing which order of court to obey.
Inibehe, you are not 1/10 as enraged as we are here, but time is a master. But let's thank you very kindly for your intervention.